Order. Welcome to this afternoon's session of the Justice Select Committee, which is looking at the work of the Ministry of Justice with the aid of its senior management team, who I will ask to introduce themselves. But just before that, if the members of the committee who are attending could give their declarations of interest, starting with Tessa Munt.
Thank you, Tessa Munt. I'm the member for Wells and Mendip Hills, and I've made my declaration. It'll be found on the website.
I'm Pam Cox. I'm the member for Colchester, and my interests are as declared.
Good afternoon. My name is Lindsay Farnsworth. I'm the Member of Parliament for Amber Valley. My interests are on the website, but of particular relevance to today. I'm a non-practising solicitor, formerly of the Crown Prosecution Service, and I'm the mission delivery champion for the Safer Streets mission.
And I'm Andy Slaughter. I'm the chair of the committee. I'm a non-practising barrister. I'm the patron of two justice-related charities, the Upper Room for Ex-Offenders and the Hampstead and Fulham Law Centre, and a member of the Unite and GMB trade unions. And now, perhaps starting with the Permanent Secretary, if you want to introduce yourselves.
I'm Antonia, Romeo, Permanent Secretary.
James McEwen, Chief Operating Officer.
Nick Goodwin, Chief Executive of His Majesty's Courts and Tribunal Service.
Amy Rees, I'm the CEO of HMPPS.
I'm Ross Gribbin, Director General Policy for Prisons, Offenders and Analysis.
Thank you very much. And we've just been joined by Sarah Russell, who did give her apologies for lateness, so I'm sorry that I didn't remember those, but welcome, Sarah. Did you want to do your declaration of interest while you're...
Hello, Sarah Russell, declarations of interest as on the register. I'm a solicitor, although I'm not currently practising. I'm a member of community and USDOR trade unions, various APPGs, pretty much the usuals. Thanks.
Well, yeah, so welcome all of you. I had a few, I'll leave it to you to decide between yourselves who answers the questions that we put, unless a member of the committee specifically wants an answer from an individual. But can we just start with a few questions about your budget and your accounts? It's widely reported that departments are expected to make a 5% efficiency cut as part of the forthcoming spending review. What areas have you identified so far? Where are you looking for that?
Would it be helpful, Chair, if I said very briefly something about the budget overall?
Yes.
So, thank you. So, MOJ delivers a large range of quite complex and highly specialised services, and the majority of our budget is spent on the pay bill, people costs and capital costs, so prison build and so on. We are highly exposed, therefore, to inflation for reasons we might go into discussing. And so over recent years, we've had a huge amount of pressure on our budget, and we have identified a number of areas as part of the Treasury's Efficiency and Savings Review of 2022, but also more recently in SR Phase 1, where we have identified areas where we had to make efficiencies, both through reducing expenditure and also sometimes in services, and also through becoming more efficient. We have gone through the process of what's called the zero-based review, which is the first part of the SR Phase 2. This is aimed at both identifying essentially ranking or prioritising spend for ongoing discussion with the Treasury, and also identifying, as is public, 5%, as he's just referred to, Chair, of potential efficiency savings. That is still ongoing discussion with the Treasury. We have identified areas with our ministers where we think we might make savings. I would say there's a number of things here. The vast majority of our spend is either on people, or it's on construction, or estates, ICT. It's on service delivery. We do have some areas of what could be termed discretionary spend. Those tend to be in the areas of delivering policy. So, for example, victims funding, community accommodation services, reducing reoffending budgets. So obviously what we're trying to do is to preserve as much as possible both those budgets and also the budgets for delivery of services through finding money elsewhere, but it's going to be a challenge.
Well, yes, and I'll bring you in a second, Sarah. It's like, you didn't say, and you were entitled to say, what the profile of the department spend has been over the last, say, 15 years, where I think it's generally received that justice of the spending departments has received the biggest cuts, a third from the resource budget, which is 85% of your spend between 2007 and 2017, and that you're still significantly below spending, the spending that it would have been in 2007, 24% lower in per person terms. I mean, so you're almost a case study of what very substantial cuts in public spending are. You're now being asked to make a further 5%, or at least illustrative cuts of that. Can you just give us some idea of how the impact that has on department and how you're coping with it?
So as you've already said, we obviously, I mean, particularly in SR15, we had a real terms cut every year on the budget, although in practice, the spend over that period ended up increasing because the department at the time was having to go back to the Treasury for more money. In SR21, we did get a significant uplift aligned with what we were expecting to be the demand coming into the system. So that was from the recruitment of additional police officers, but also from the impact of getting the Crown Court backlogs down. Post-COVID, we were expecting a big inflow into the prison system, and therefore we did get some more money to deal with that. In fact, largely because of much higher inflation than anticipated, our budget still became under huge pressure. So you're right, Chair, to say that our budget's under a lot of pressure, and we are also continuing to face significant increases from additional demand. So it's not just a question of holding still for us. There's the flow in that we're expecting because, as we know, the prison population is projected to continue to rise, and we also want to find money to do things like continue to bring down the Crown Court backlog. So I'm essentially agreeing with you, which is I think we're under a lot of pressure. We're working closely with the Treasury. We are going to have to find, I mean, the fiscal context says we are going to have to find efficiency savings and other savings, and we're going to seek to protect the sort of services as much as possible.
And obviously some of your budgets are without your control, or at least in the short term are. Perhaps policy changes might alter that. But you will want to be looking at areas where you can save money as well as areas where you need to spend money. You want to take the reins, as it were. You don't want to constantly be going back cap in hand to the Treasury because you've had overspend. So what are those, just give us one or two concrete examples. Where do you expect to take money from, and where do you expect it to go to?
Well, so the first thing to say, as you've just identified, the government's policy is to try and get a grip on both stabilising the system but then making it more sustainable. And to that end, we've got 2 independent reviews underway, one on sentencing, which is specifically looking at how we can reduce demand across the justice system, considering the factors which have the capacity to help us do that. And the other is the reform of the criminal courts, which is looking at both how the criminal courts can operate more efficiently, but also in potential policy changes to reform the courts to ensure that cases are dealt with proportionately in the light of the current pressure on the criminal courts. So that's the kind of strategic plan. In the immediate term, we're both looking at areas where we might try, as I say, we're trying to protect the front line. The Treasury will rightly expect us to, as we are doing and have done, gone through line by line on our spend to identify areas of efficiency. I don't think I can, because this is still subject to the internal negotiation with the Treasury. I don't think I can be too specific about areas. But the one thing I would say is we've made a big investment over the recent year in particular, and slightly longer than that, into our digital and technology capability. And we're seeking to essentially both put our services, we've got a lot of legacy tech debt, I'm sure we'll come on to that as well. We're looking to put those on a solid footing, but also to look at things like how AI and digitising and automation can save money over the period of the review. So we are looking at areas where, nobody likes talking about invest to save anymore because there's not much money available for investment, but where we could identify areas where some additional investment in tech and digitisation and automation could yield savings, productivity improvements and efficiency down the line.
Yeah, we'll come on to that maybe later. We talk about the reform programme. But given what you said in terms of priorities, why is it that the most significant increase in the last year has been in policy, corporate services and associated offices of your various budgets, which has gone up by 336 million or 36% from estimates?
Can I ask Chair what page you're on the report?
Yeah,
sorry, you're on another note.
Yeah, no, yes.
Are you talking about pay? Are you talking about? I don't think that's the increase in money. You're talking about numbers.
Yeah, I'm talking about what's under the heading. You can tell me what it consists of: policy, corporate services, and associated offices. Where comparing the supplementary estimate and last year's expenditure shows that had gone up more than any other area.
So I'll ask James to come on to the specifics of the SUPs, but is this, you might be referring to numbers, well, in fact, what did we put in that policy was presumably some of the provisions, but James?
So I think the strategic enablers, if you look at the change between the mains and the SUPs, as you know, between the mains and the SUPs, the Treasury had agreed with us at the beginning of the year certain changes in budget that would arrive at the SUPs. And so how we budget for that is, because it's a zero-sum game, we have to, at the mains, reduce the budget for our HQ, knowing that by the time of the SUPs, when the Treasury put forward the supplementary estimate, that there would be the additional funding within it. So that's what the journey from the mains to the SUPs is about. How do we, where do we hold in the departmental budget the difference between what Treasury had sort of provided at the mains and then what came forward at the SUPs.
But what's in this particular line? Do we know
So that would be the costs of classic HQ functions, but then also some of the FM spend and other property spend that sits in my group, for example. So it's a variety of and some ALB spend and grants for victims, and so there is a lot of front line in that, as well as civil servants.
On that point, can I ask you to deconstruct your acronyms? Because I'm not fully familiar. I presume FM, well, I know what FM
is. Facilities management. So some of those, so the way we organise the department in my group, a lot of the professional services that support Amy and Nick and other frontline operations sit in the headquarters, because that's how we drive efficiency.
No, I understand that.
Yeah.
I also understand facilities management, but there's some other bits that
I was talking about I was talking about our headquarters and the SUPs being the supplementary estimate, but I think there were the acronyms I used from memory.
It's looking at headings. When you look at HMPPS or HMCTS or legal aid, you'd expect to see if there are going to be increases that they would take the lion's share of it, whereas the lion's share seems to have gone into what's effectively head office costs.
Although I think the point James is making is that supplementary estimates were essentially adjustments in a year.
Right.
It's not the same as an increase year on year. So it's just what happens in a year when we have pre-agreed with the Treasury during the first part of the year, some adjustments. So, for example, we've also done, as I'm sure we'll also come on to, switches in the past between CDEL and RDEL and things like that at the SUPs. So it's just an adjustment mechanism.
That was my next point, but before I do that, I'll bring Sarah in.
So do you get SUPs every year?
Yes, it's part of the fiscal process. The supplementary estimates is a core part of the fiscal process, yes. So there's the main estimates and then the supplementary estimates.
As a bystander, when you say it's sort of an in-year adjustment, does it mean that, arguably, for instance, that a budget is set that you are to try and live within, and that budget may or may not be feasible, and then when it's not, then SUPs are really how that actually gets dealt with? And does that happen across all departments?
Well, so it's not, obviously what happens is you agree at the start, and James is the person actually doing this for the Treasury, so he'll want to give a lot more detail than me, but essentially what happens is you do an adjustment on your RDEL and your CDEL, and it could go either way. So sometimes there's an emerging pressure.
So you'll have to
sorry, can you tell me what an RDEL and something else is?
Sorry, apologies. Resource DEL and capital DEL. So essentially there were various types of public money, but the main distinction is between resource spending and capital spending.
Okay, so what's DEL mean?
departmental estimate.
Departmental expenditure limit.
I'm very sorry. I'm
No,
sorry.
not at all.
I don't understand what you're saying, and I just ask you to. And I guess probably if anybody's watching this, they might not understand either. I don't know whether people spend their afternoons watching the Justice Select Committee, but frankly, I hope they do.
They should.
Completely understood. So resource DEL or expenditure is essentially kind of running. That can be seen as running the organisation, and capital is investment in the asset.
I understand the acronym. I'm completely cool with what you have now explained. Thank you.
So it can go up, and if I should continue, it can go up or down. In some cases, we might be offering money back. For example, if we know we're not going to be able to spend our full limit that year on, say, the capital side, we might offer some capital back. And the sort of things that can come into the supplementary estimates would be unforeseen pressures. So if, for example, there was a loss of income that was unexpected, so if, in fact, in the case of the year in question that we're considering, we had an unforeseen less income recouped than we were expecting because income didn't keep pace with the trajectory post-COVID. So therefore, that's the sort of thing that we'll go back to the Treasury for. I can say a bit more if helpful, or that might be enough.
That's probably helpful, but I think really I had two questions. One is, do you think you can find 5% of efficiency savings, or actually at least just cuts? And the second is, you were quite reluctant to suggest where those cuts might come from, if they were to be so termed. So but I was wondering, let's say you had a 10% increase in your funding, what could you do with that?
Okay, well, that would be a heady moment. So on the first, just to be clear, it's no disrespect to the committee, it's just that in an interim process where we're still talking to the Lord Chancellor hasn't made decisions, and nor have it been decided by the Treasury, it wouldn't be appropriate for me to talk about where we think what we think the 5% might apply. I think the efficiency savings might, in our case of our budget, will presumably involve some reduction in services as well as pure efficiency. In the year 23-24 and 24-25, we took 1.6 billion out of our budget, including 100 million of pure efficiency savings, mainly through 4 efficiency programmes, some of which we'll come on to talking about, of 100 million this year. So we have been taking, over a long period, we've been absorbing inflation, which has been incredibly high, and we've been taking large sums out. So I don't think there's a lot of additional money there to be found. If I were given a 10% increase, the first thing to say is that given the demand we are facing coming into the system, I think that some of that would just be put towards standing still. But obviously the two things I most want to do is to get the Crown Court backlog down. So that would be increase in sitting days, but all other things, implementing the reforms that we expect that the independent criminal court review will come up with, but also on the sentencing review, implementing those, continuing to build the prisons we need, and invest in staffing and things for those new prisons. At 10% also, it would slightly depend, you'd expect me to say this, on whether it was 10% real or cash, because actually a flat real settlement is not that significant, over a multi-year period is not that significantly different from flat cash plus 10%.
You're not the only department that does this, but you mentioned, I think, a few moments ago, using capital money to support revenue budgets. Could you summarise where you are with that? What sums are involved, which budget is going from and to, and why you feel the need to do this?
Well, so the Treasury, it's normal policy if you are looking to have an overspend in some areas. So, for example, unexpected loss of income means you need more money, or you need more resource DEL because you're absorbing wage increases or something. It's normal for the Treasury to expect departments to look first to their own budget to reapportion before thinking about giving additional money. Exceptionally, and it is unusual, in the year in question, we agreed with the Treasury that we could do a switch. So we had capital that was not being spent, that was going to, for a range of reasons, on the prison build programme, so delays connected with delays in planning permission, site issues, ecological requirements, all the things that had led to the delays in that programme. We essentially ended up, we couldn't spend all the capital on prison build that we wanted to in that year, and we had a shortage of resource. So we did a switch, which in total was, I think, about £700 million over the 2 years as the switch. Now, again, this is not good, we're not expecting, we're not relying on it for this year because we don't. It was unusual for the Treasury to allow us to do it, although I think they did let us do it for 2 years in a row.
I mean, there was also a sum of 85 million of capital that you returned to the Treasury due to supplier failure impact on prison expansion and maintenance.
So again, this was, as you'll know, ISG went into administration. They were doing a large number of works for us. So when they went into administration, we couldn't spend all the money that we would have been spent to them if they hadn't been in administration. So what you do, the absolutely crucial thing at the moment is at the time you identify that you might have an underspend, you offer it up to the Treasury. Hence, as I say, sometimes you're offering it up during the SUPs, because the last thing, the thing that is the least helpful is to pop up at end of the year and say, oh, by the way, we've been holding on to this. We thought we would have an emerging underspend.
And, so that is just due to the ISG failure, is it?
Well, it's primarily due to that. I don't know if there's other... Amy, did you want to say something about...
Yeah, I mean, the ISG exposure was quite significant for us. There was a couple of projects in HMCTS, but we had both the 20k and maintenance projects, and they were delivering FSI, so fire improvement work. So it was a really significant kind of exposure for us in terms of what couldn't then be delivered and what we're now going to have to go back in, you know, and recontract with our rest of our supplier base to continue the works.
It's not to do with your existing maintenance contracts. They're with Amy, yes, in the.
So no, not really. There's two levels at which we do maintenance. Those existing permanent contracts, they're for small maintenance, small works. Anything that's significant goes out to contract. So all the stuff we're talking about. So priority one maintenance. So, you know, replacing a boiler, replacing a roof, building a new wing, doing fireworks projects. They all go out to specialist contractors.
Do you anticipate this happening? You talk about 700 million that's effectively gone out of the prison building programme, which is unfortunate.
Over 2 years.
Over 2 years.
Yeah.
Unfortunate, to say the least, given the need for prison places and the fact that it's being used to fill a gap in your revenue funding. But what can you say about the future? What can you say about next year, the year after, in terms of that? Presumably you've got revised targets for completion of the prison programme.
Yes, so the prison programme, I mean, there's 14,000 new places that we're currently building. That is, they're due to come on stream by 2031. I mean, I think Amy would say, and may want to say in a moment, that the administration of ISG has been damaging to the programme, but obviously what we are, highly damaging to the programme, but what we are attempting to do is to keep the show on the road to deliver those 14,000 places, because it's absolutely essential that we have them coming on stream. And then so we would never plan or hope for or seek slippage. We always want to spend as much money as we can in a value for money way delivering the prison build programme. It's just that I observe that there may yet be areas, because we've got to get those places, that maintenance done by someone else now, and we haven't reallocated it in all areas, have we?
No, that's exactly right. And then the other things that all of you will be very familiar with, the planning delays we've had to Garth, Gartree and Grendon, and what that's done to
Yes, I've already gone down that. We've got some questions coming up on prison programme, so I'll save those for them. Thank you. But did you want
Yes, can I just ask you, I wondered what the costs of re-tendering the ISG work were.
Yeah, so certainly I might pick up for HMPPS. I don't know if Nick and James then want to pick up, because it wasn't just HMPPS who had contracts in the MOJ with ISG. But first of all, there is kind of the contract overhead, so just the overhead of our back office staff having to re-let the contracts, etc. So that will be one set of costs. And then we don't fully yet know how much it will cost for us to get new contractors in, whether they will stick to the same price, whether it'll be more expensive. It's likely, once we've re-let all the contracts, that it will cost us quite considerably more, given there's been inflation in that period, and given in some sites they were actually part way through work. And I doubt a new contractor will pick up that work halfway through. They'll want to go back and assure themselves that, you know, the work has been done to their specification, etc., since they have to sign off. So it's highly likely there will be costs involved in this, and we just don't know what all of those are yet.
And so when do you anticipate having some idea of the costs of the loss?
Probably in the next 3 to 6 months. You know, we'll have an idea every time we relet one of the contracts, but there are quite a few to do.
I might ask you to write to the committee with some information about that, please, as it comes along. Thank you.
If you've got these contracts and they're across different areas of departmental operation, did you not have any clue or forewarning about what was going to happen with ISG? Because it's pretty, I mean, since Carillion, it's the biggest failure of a contractor, isn't it?
Shall I pick up something on that, and then James, I want to say something as well. So, of course, it wasn't just MOJ that had exposure.
Well, even more so, yes.
So it was the work with ISG was largely being led out of the Cabinet Office, but we were obviously working with them to look at what the impact would be and prepare insofar as it was possible to prepare. But of course, when you're in the middle of a contract, you're not during that contract seeking to go out and do a kind of potential retender. You're doing everything you can to ensure that the contract doesn't fail. But we obviously were working with the Cabinet Office closely to do that sort of preparation. So, James.
Yeah, so generally we keep a close eye on our key contractors and their financial health. We're not public about the suppliers we're worried about because that is likely to precipitate more challenges for them. But we had been working with ISG as a government, understanding their position for a while. And as Antonia said, that afforded us the opportunity to do the contingency plan that we were able to do. So, you know, in the event of their falling into administration, which ultimately is what happened. So we were well prepared for what came next. But the procurement process, you know, has to unfold. So we can't comment today on just how much that's what the cost of the new contracts will be. But we keep there are a number of methods that we have for keeping an eye on the financial position of our key suppliers.
So can you remind me, when was the contract let?
ISG,
yes.
We've been working with ISG for a number of years.
Okay, so if we focus on particularly the work that they are undertaking, there's the 2 prisons that are being rebuilt, and I recognise there are other things, there's maintenance work as well. When was the last letting of that contract? When were they last scrutinised and permitted by the government to go ahead and they were financially fit? On what date was that last?
So we were carefully managing, so on existing programmes we were carefully managing our cash flows to make sure that we were paying for work that was only due, so we weren't exposed in the event of their administration. I'd need to look at when the last time we let a contract with them, because we have a framework agreement we're doing, so they do some very large projects and some very small projects, but they, government work was a significant proportion of their revenue streams. So in these situations, you can cause the ultimate collapse of a company if government decides to stop issuing contracts with them. So there's always a careful balance between at what point do you stop, but we're being very cautious.
Bearing in mind it's taxpayers' money, somebody stops before it all collapses.
No, indeed, but
really.
And indeed that was, we were looking very carefully at our placing new contracts with any company in financial distress. But some companies in financial distress can recover. So what you wouldn't want to be doing as a government is pushing them over at the same time. So I'm just saying there's a judgment, out with the ISG example. There's always judgment to be made about how government responds when there are concerns.
I would ask you to inform the committee in writing, if you would, Chair. I'd like to know that information about when the government last decided they were financially fit to take on work with the MOJ and others, but I'm particularly interested in the MOJ, and to have some understanding of when it was that the flags went up the first time, because it sounds as though those may be the same sort of time, which is not necessarily totally sound decision making for taxpayers' money to be spent. But anyway, we'll see.
May I check that so obviously we're happy to write on that, but also to say, in a situation like this, we would move absolutely in lockstep with the Cabinet Office and with government policy. We wouldn't be making our own judgments about fit. I mean, we have our own basis on which we're deciding whether or not to let a contract, but things like fitness for the contract to be let and proximity to administration would be somewhere where we would be working very closely with Cabinet Office, because they'll be owning it across government.
Yes.
I wondered whether we might move our discussion of contracts to this point as a natural
That might be helpful.
segue.
No, I'm happy to
or
do that. Are you happy? We'll do staffing off.
Yes, as long as we do it the next one.
Sure.
My commitments.
Gotcha.
Thank you.
Thank you. I was going to continue this discussion around contracts and we acknowledge the scale and complexity of the contractual arrangements of the MOJ and other departments. I understand from the House of Commons library team there are 450 contracts in total, but I then we heard as a committee from Minister Timpson that in fact there are 1,112 active contracts delivered by 539 suppliers across with HMPPS. For the purposes of the committee and anybody watching, I mean, could you broadly set out the types of organisations that MOJ contracts with in relation to prisons in particular? I'm thinking about non-outsourced prisons and the kind of activities they cover.
Okay, sure. So I'll say some things, and then because you're particularly interested in prisons, Amy will want to add. But the first thing, I mean, just to sort of cite it overall, so obviously we have an incredibly complex portfolio of commercial projects, many of which are with prisons, but we've got many in courts and actually in the border in our other agencies and elsewhere in MOJ, and they would range from contracts held by individual prison governors for particular services to across the portfolio contracts held, centrally, and we've actually got about £5 billion of our spend is in contracts. So back to the chair's an opening question or two, that says quite a lot about the extent to which we have how much money one has to draw money out of or to seek efficiency savings from, because we've got £5 billion tied up in contracts. We obviously work with a large range of contractors from SMEs to very large organisations and the sort of things that we are contracting on. So we've got property construction services, so that would be people like Kier, like Waits, Lang O'Rourke, etc. You didn't ask about private prisons, but you asked not about private prisons, but as you know, we contract with those. And then we've got IT digital services, so that Microsoft, Vodafone, Amazon Web Services, BT, etc. We have got facilities management, aforementioned, so Amy, OCS, Equans. We've got resourcing contracts, so helping us with resourcing, so Alexander Mann, Brook Street, Hayes. And we have then prison services, so Serco, Bidfood, DHL, Hovis, and neat segue over to Amy to say something about the prisons.
Well, I mean, I think the boss has covered it really, but there's everything from kind of actual delivery things. So, healthcare is often contracted, but not commissioned by us, commissioned by NHS England, devolved in Wales. Then you've got things like education contracts, all big, done in lots or nationally, then right down to things like how we buy Snickers, how we buy bed sheets, how we buy clothes, how we buy uniform for staff. And then there are some things that are done locally, so commissioned rehabilitative services or things that you might buy in, like very specialist advice is often quite local, and some of those from very small organisations, peer support, that kind of thing.
Well, thank you for setting that out, and we do respect the complexity of this and the fact it's been developed over many years. As a committee, we've heard quite a lot of concerns about the scrutiny of the performance of some of those contractors, indeed many of them. So, and from our visits and from witnesses we've had to our inquiries, and we've got a prison maintenance backlog, we've got fire safety risks in some cases, we've got an insecure estate that allows drones and weapons in. We've got prisoners locked up 22 out of 24 hours with little access to purposeful activity. Now, I appreciate rising prison numbers have contributed to that, but I think we're all minded to ask about the performance of those contracted services. So prison governors have reported their concerns to us around this. Witnesses to this committee, last week we had Dame Carol Black, who's the government's independent advisor on drugs, said she thought the current commissioning framework for healthcare in prisons wasn't fit for purpose. She said she'd found it difficult to get data on this because it was deemed commercially sensitive. We also heard in the same session from Charlie Taylor, Chief Inspector of Prisons, who said he didn't have full access to data on the commissioning arrangements or the performance of contracted services, again because of commercial sensitivities. Looking beyond the prison-based contracts to the wider criminal justice contracts, our briefing pack today is full of examples from the National Audit Office quite alarming findings from them on the performance of everything from court IT systems to court escort systems to electronic tagging, monitoring to prison maintenance. So it seems wherever you look, there are concerns about the performance of these contractual arrangements. So given that, and it's a rather long question, how can it be that the performance of services contracted to deliver public value for money in courts, community justice and prisons don't seem to be subject to full public scrutiny?
Can I just, I'm going to ask Amy to say something about prisons and Nick, I want to say something about courts, but what do you mean by are not subject to full public scrutiny?
Well, I think when the Chief Inspector of Prisons doesn't have access to the data and we as a committee don't have access to the data on performance, we understand commercial sensitivity, absolutely, but I think our focus is on performance. If they were performing well, probably wouldn't be asking these questions, but given the situation we've seen and observed in prisons, it seems that performance may be a factor here, and how are we monitoring that?
Yes, okay. I mean, I think there is, as you've already you've hit the nail on the head, because a lot of this will be subject to commercial confidentiality. But why don't I ask James to say something first about that, and then we can talk about prisons and courts in particular, if that's helpful.
So contracts themselves are published, so you'll have that degree of scrutiny. To your point on performance, some of that is commercially sensitive. In terms of what we do internally, each major contract you'll have a senior business owner who's responsible for working with that supplier, and that might be at a national level and at local levels, carefully monitoring the performance of the contract and the supplier and where it's falling short, making sure that we're working, remediation plans are put in place, and that if penalties are applicable under the contract, that they are being enforced. And then in my team, I have the procurement and commercial function. We have a small team of experts who help those people working in the business make sure they fully understand the way the contracts work and the mechanisms that we have. And so that's the overall approach. I think on the list of some of the, and Amy and Nick will talk to, we work really closely with many of our third-party suppliers, and many of them have really stepped up to through what has been a very difficult period in terms of capacity. And I'm sure we'll talk about the escort contract, but actually if you think the contractor there has delivered hundreds of thousands of journeys for us, a small proportion of which may lead to people being not in the dock at the right time, and we understand completely the frustration for other court users and judiciary and others about that, and victims. On our facilities management, we have third-party suppliers, Amy, that we've talked about, others. We have an in-house facilities management company, GFSL, which was set up after the collapse of Carillion. And all of those suppliers have been working with us to ensure that they are turning, so cells that are taken out of use because of vandalism or damage, getting them returned to use within 24, 48 hours. There's been a spectacular improvement in those areas. So I think, just for balance, there are a lot of suppliers who are really working with us on some of the challenges that we face.
Just to give you a few examples from the court. So we don't have quite the breadth of contracts that the prison service do, but we've got quite a few. Our big ones are facilities management that we've spoken a lot about, and also court security. So we have very active contract management with those suppliers, and as James says, actually, they really have stepped up. I'll be sitting down with them tomorrow, actually, our facilities management supplier, and I sat down with our security supplier just a couple of weeks ago. We will go through every single KPI and see how they're performing against that, and encouraging them to do better. Broadly speaking, they're our big two, and broadly speaking, we think they're performing pretty well. So our facilities management company did 900,000 jobs in the courts last year to keep them running. But we've got pretty tight contract management. We do provide quite a lot of transparency around that information. So I was before the House of Lords Public Services Committee the other day talking about one of the other big contracts, which is language services. And we provided that committee with a lot of information about those KPIs. The key one there is what we call fulfilment rate. So whether an interpreter turns up to court, that's 94%, and that's fairly public. So we do, we really are on them, working with them, but also provide as much transparency as we can.
I think it would... offer more confidence in the system if it was more transparent, if there was a further conversation to be had about the transparency of these arrangements within reason. But I know we need to...
I don't really understand. Obviously, some parts of it will be commercially confidential, like the bidding process, maybe. If you're awarding competitive contracts, surely it's a matter of public record as to who has bid the lowest or why, or how that's been marked and what happens there. And equally, if you're then going to penalise a company that's won a contract, then that should also be public, shouldn't it? What you're fining them and for what reason and what percentage of the contract that is. So it does sound to me that you're rather hiding behind commercial confidentiality, not to reveal very much at all.
I think it depends on the terms of the contracts and when they're let and what's there. So I mean, I understand the points the committee's making, and we're always happy to where we can't put performance information into the public domain. We're very happy to come and brief the committee on those areas.
All my colleagues want to come in, but I'll just one more point. I mean, for example, we were asking about the Sodexo Forest Bank contract recently, and I didn't specifically ask for this information, but added on to the response I got from Lord Timpson was, very fairly, was a list of all the penalties that have been paid out. Now, it doesn't tell me a huge amount, because it doesn't tell me what percentage of the contract that is, how punitive this is in relation to it. But clearly you feel able to give that information in that context. But other times we simply met with a stone wall, and it looks like other people like the Chief Inspector are as well.
And I think in that letter we talked about the fact that some of that information wasn't in the public domain as well. So I think this talks to the where we're sharing with where we're sharing with you. We're clear about what is in the public domain and what isn't being put in the public domain.
That's up to us.
Okay, so
can I just follow up on that? Can I ask you, what do you think Charlie Taylor means when he says he cannot get the data? What do you understand? What conversations have you had with him when he makes? I'm sure you would have picked up that comment last week. What do you imagine he means by not being able to get hold of the information that he needs?
Well, I imagine that he's asked. I'd be quite surprised if he's asked HMPPS for data that could be shared and that hasn't been shared.
Because His Majesty's Inspector Presence, isn't he? He should have access to data.
Well, I agree. So that's why I'd be surprised if he's asked for data that is available, that could have been shared. I'd be surprised if it wasn't shared. But perhaps you could give an example specifically.
What I might ask you is more in the generality, and that is if you could explain to me what would not be available to Her Majesty's Inspector.
Well, I mean...
What would not be available to?
I mean, opt out or opt in. This is a... data.
Actually, he should have access to everything that he needs in order to interrogate the veracity of the information he receives, and to be able to make a judgment which can be utterly critical to the survival of some people's careers, or not.
Well, could you give an example, perhaps?
I'll go back to his chair, if we may, and I might ask the committee clerks to help us, but I can assure you he was very clear last week, was he not, that he could not access the data that he required in order to make assessments on particular places. And we were talking about a number of we were talking particularly about drugs and prisons and drones and all the rest of it. And weaponry and goodness knows what else.
And it might be that we don't have... I'm just wondering, when you say that, it might be that we don't have the data, which is, of course, different from us having the data and not sharing it with him, which is why it would be very helpful to have, perhaps, from him
I felt that there
examples.
might be a bit of curiosity from one of you. I'm not sure.
If we could,
I'm sorry, but there might be a bit of intellectual curiosity when he's making statements like that to this committee, that you might actually have interrogated that statement and checked what it was that he was referring to.
Sorry, Ross is going to come in. Can I just check I've understood, Ms Munt? Could you just repeat what you just said?
I said I wondered whether there might have been a bit of intellectual curiosity around when he is making a statement like that, because it's quite critical. Well, it appears to me to be quite critical of the system. And I feel that one would... If someone had said that about my department, I think I'd be on the phone to him the next morning saying, OK, what do you need? What have you not got? Why have we not provided this with you? You can't have this and you can have that. Thank you.
Senior officials in the department do meet Mr Taylor very regularly. I know that Amy does, as does Phil Coppell and many other members of the team. I have a stock take meeting with him regularly because the policy function sponsors HMIP, and I often check whether he is receiving the necessary information from the department. So we will obviously need to follow up with Mr Taylor and find out what it is that he's not happy with. And we will do that, but I can assure you if he said he wasn't receiving information, we would clearly take that seriously. Now, what we could do about it would depend on the matters that the PermSec just said a moment ago, but we do regularly speak to him and his team, and it is an important part of the department's business. I don't know, Amy, if you want to add anything.
Look, just as Ross has said, we meet with Charlie really regularly. Any information at the local site that he needs to conduct inspection is absolutely statutorily available to him, and we give it to him. I think what Charlie was talking about was national contracts, like we've talked about a bit already, like FM or an ISG contract that was going to redo the netting, for example, that prevents drones. He would like to know where is that on the relative priority list, how much will that cost to deliver, etc. Some of that is readily available, some of it is not because it's in procurement, all of those kind of issues. But just as Ross said, we will absolutely follow up and check that he's got everything he needs. But we speak very regularly.
Yes, I mean, my sense, Chair, is that for us to do our job properly, we need to understand the situation. And from what I heard last week, it wasn't clear.
I mean, I can give you a brief. I mean, this is, as you say, something you may well want to take up with the Chief Inspector yourselves. But in response to a question from Pam Cox on whether he had access to data on the commissioning process, he said, no, what we get told is, as Dame Carroll said, that it is a commercial thing. Certainly we see the results of commissioning when it's not worked out, i.e. reported health services are not as effective as they could be.
Can I just pick up on we obviously are not the commissioners, that would be health. So even that commissioning process, that is done via health, bought by health and regulated by health, because they are responsible for health services in prisons as opposed to us, which may very well explain why he feels one step removed from that part of the process.
With respect, it was my line of questioning that gave rise to that discussion last week, and my sense was it rose out of a discussion around health, but it was a more general reflection of his about his ability to have access to data around the range of contracts that we've discussed today. But it would be worth following up for sure.
I'm sorry, Sarah, did you want to?
Obviously, there is an issue one way or another about commercial sensitivity within these contracts. Do the contracts themselves stipulate what is and isn't commercially sensitive information, and who writes the contracts?
Well, the contracts are subject to agreement, obviously, and in some cases they would.
Yeah, so there'll be specific terms in specific contracts, and they're subject to the public procurement regulations. Contracts are published routinely. So that is a matter of public record.
Are there any contracts in which you feel the commercial sensitivity clauses have prevented you from making inquiries that you would have wished to?
There is no constraint on us being able to interrogate those contracts. There are some areas where it may be against taxpayers' interests to put information into the public domain if it would change the bidding behaviours of other providers in future. There might be some areas for security grounds that we say we wouldn't routinely put that information into the public domain, but from us as a team there is no boundary in terms of with the suppliers our ability to scrutinise their performance and what's going on under the hood, as it were, of a service or the goods that were being provided to us.
The constraint is on the public, it's not on the parties to the contract, and we would be one of the parties to the contract.
Okay. In terms of the constraints on the public, insofar as we are the public for these purposes, how would you suggest that we can assess what is the mechanism for assessment of there is a danger that there could be a perception, and I only say a perception, I am absolutely not making this allegation myself, I want to be really, really clear here. There could be a perception that the civil service worked with the contractors to produce contracts which made it difficult for us as representatives to effectively scrutinise what goes on. So what would you say to that? Or are there mechanisms in place that we're not currently seeing for scrutiny of this that isn't us?
Okay, well, so look, the first thing's I haven't heard that allegation before. And the fact, as the Chair's already said, this is my third time in front of a committee this calendar year. So we could not be more enthusiastic to be scrutinised by Parliament. In terms of what's available, we're bound by the terms of the contract. But what I see in the Ministry of Justice is people in teams, all represented here, working incredibly hard to focus on the delivery of that contract. And in fact, in some cases, notably in Amy's area, if the contract fails, we have to step in. So actually, we're working with the contract. We don't want them to fail. It's not adversarial. A good contract is one where we're getting the best possible value for money for the taxpayer. We've got complete transparency so that we are able to scrutinise what that performance looks like, that the performance bears relation to the actual outcomes, because at the end of the day, we're trying to deliver for people in the street, for the citizen, and that we're able to scrutinise that and, where needed, hold to account. There's a large number of penalty clauses and different aspects of the contract that we would have to administer, but often we'll be working with the contractor. I mean, a good example might be, electronic monitoring, for example. We'll be working with the contractor when they're off the delivery schedule to help get them back onto the delivery schedule. And in cases where we don't think that can happen, and as has been evidenced in fact in, for example, stepping in to prisons, the public sector will have to step in. But our first job is to try and get an effective contract that delivers for the citizen, that provides value for money, and we are the people, and we never forget this, who scrutinise that contract to deliver. And the people who do it, I'd actually like to thank them because they do an absolutely fantastic job.
And also, I guess, Mr. Russell, just from my perspective, I don't know what my motivation would be to do that, since we are trying to run a very complex, very difficult, very risky organisation in which I need all of these players to deliver. So setting up a contract in which we were somehow in cahoots with a provider who wasn't providing would just make my job extremely difficult, if you see what
Yeah, I'm not suggesting you're personally corrupt. I want to be extremely clear. I'm absolutely not suggesting that at all whatsoever. I just think, just the question needs to be asked about how that functions.
As a general point, there is much that we can talk about, right? So I think we're focusing on what you can't talk about. There is much that we can talk about and transparency around that. Where that is difficult commercially, it is routine for departments to brief a committee like yours, like the Public Accounts Committee, out of session, in confidence, about what's going on. And so that, and that enable, so your
the answer to the question.
Yes. Which is, and we've done that in the past, other government departments have done that, and, we're happy to do that within reason.
Well, let me take an example, because I show where our concern comes from, which you know very well. It's not just about public money, it's about public safety as well. So if you look at, say, the tagging contracts, which have had a very checkered history, particularly in relation to Serco and previous malpractice in relation to that. Serco had the contract back, at least the monitoring contract. G4S, I think, had the hardware contract principally. There are other providers. How can we be assured, given the history of that, that those contracts are being run well, particularly against, we've seen, you may say it's unfair, but what gets into the news is when people aren't fitted with their tags when they should be. But we also know there's a substantial increase in tagging for different purposes, whether it's alcohol tagging or it's early release or it's licence periods in that way. And it looks like there's going to be substantially more of that in the future. So how, without being able to see the way that contracts are running, are we able to know that the same mistakes that were made in the past aren't being made now, and people aren't walking around without tags who should have them, for example?
Amy, do you want to pick up on operational performance side, and then I'll...
Yeah, look, I mean, James will pick up on what we learn and what lessons we learn from that episode and how that is now tried to be covered in contract and the way we manage those contracts. But from an operational perspective, I have been meeting with very senior leaders once a week from those organisations to try and make sure they are doing operationally everything they absolutely need to. I monitor those data and key bits of data very regularly to ensure there isn't a backlog. But I think both you and the previous question, also, regardless of whether we were doing this in-house or by contractor, what we have done is change both the operating environment and the demand quite considerably in these areas, regardless of who's delivering these various contracts. That means whether we were delivering it directly or with someone else, we have to work through those issues. We have to operationally make them viable. Just the same way that if I was delivering tagging in-house, the asks that have been made for them over the last year, and you mentioned some of them, would be a considerable step change no matter who's managing the demand. And so we really have to work together to ensure it. So James will obviously pick up all the contracting lessons that we've learned, but operationally I am absolutely on those numbers. And as I say, we work with people to try and give them good line of sight about when those volumes might change. And we all know, for example, that the sentencing review may change the volume requirements again, and we have both tried to manage changes in the contract so that we can be flexible when those changes come, but also ensure operationally they can deliver, which means very practical things like getting onto their new systems, etc. And in fact, the whole of the CJS, because you know the biggest actual single user of tags is court bail, as opposed to anyone directly in my responsibility. We're all going to need to work together, and the other thing is we have a really active stakeholder environment where we meet with the police very regularly, we meet with the PCCs, and in fact, me and a colleague are meeting with that group only next week as well to talk about how we would manage that and how we would manage any future volume changes.
I think what we want to be reassured of is that these are well-written contracts and that they are monitored. And that will be true. That's the way that performance works. So taking another example, prison transport, where we're told 98% compliance, but you talk to any court user and they will say it is one of the major reasons for delays at court. So how do we square that circle? Is that because the contract isn't written tightly enough? Is it that the figures being reported are inaccurate, or that all the court users are wrong?
There's a couple of things. I mean, James will want to talk a bit more about how the contracts are written, but in both EM and PECS, what I can tell you is there's been a lot of learning for a lot of years. These are not Generation 1 contracts, they're multiple generation contracts, so we've learned a lot about contracting. I can absolutely assure you that operationally both those contracts are managed very, very closely. But the truth is, to the PECS, to be really honest, the operating environment. So the PECS contractors might very well do what's in their contract, but because of capacity, for example, we might have had them doing extra redirections the night before, which means their vehicles are not in the compound that they should be. And to be fair to them, that is really not their error. That's because they were doing extra move for us to manage capacity. And so I have full sympathy for the court user where they might well have arrived late, but it might be because the journey that we had asked that PEC contractor to make is twice as long as it should have been because of the implications of capacity. So that's how you square those two figures. It's the operational environment in which they're trying to work in.
So the data, well, I was going to say, so the data will be the failure when Serco failed because of something that they did, whereas what Amy's describing, there'll be other instances where it won't show up in the 98% figure, but it would still have resulted in an outcome in court that was different. So Nick,
so we do publish figures on for what reason a trial might have been ineffective or cancelled, and that figure looks slightly at odds in what the PECS contract fulfilment figure tells you. So it tells you something closer to what I'm sure you've heard from the legal profession, that, and I've got the figure somewhere, but in the low sort of 1 or 2% of cases, a trial will not be able to occur because of late delivery. That's a much higher figure than you'll get through the PECS contract fulfilment. They are different things. So we try and be as transparent as possible where we've got system issues that are being affected by judges, court staff, CPS, but also suppliers. So that information is available. But I think on that point of transparency, I think there probably is more we can do to make some of those delivery figures easier to understand and more readily understood. And my team are talking to Amy's IND PECS about trying to get that a bit better, so you've got more faith in it.
Yes.
To Amy, a quick question, really, if I may. You've said it's in your interest to work with the contractors to make sure that things are better. My concern is that because the contracts are clearly not working, we hear it time and time again. We've given you some examples of what we've heard from the front line, as it were. It must take up a lot of your time and effort to try to work with them. What's the answer to make for the future so that you're not spending a lot of time trying to hold their hands in some respects to get the contracts to work properly? Is more public transparency maybe a leveraging to make sure that they in themselves, the contractors in themselves, are set in their mind to the fact that we can't fail because people will know about this in a much clearer and more transparent way? Or is there another solution? Because I've been on the front line myself, and I've been there when trials have gone off because the defendants aren't brought to court. I've been there when somebody's there being prosecuted for breach of their probation conditions, and it turns out that their tag hasn't been working properly and things like that, so or hasn't been installed. So that isn't going to be helping with, in my world, the court backlogs, these additional challenges. So I think what I'm saying is, how can we improve things going forward for you and for your colleagues?
Yeah, look, thank you. It's a really good question, and it is true that it takes up a significant amount of our time to manage these contracts. But the ultimate answer is we have to make the operating environment more stable for anyone to operate in. So if we go back to EM, if I was the provider of those services, I don't think I would have some of the challenges that they have. I don't think it's necessarily a commercial contractual boundary. It's that some of the operating environment needs to be more stable. And a lot of what you're talking about in terms of, people coming to court and being delivered late, etc., that is driven by being occupied at over 99% for the last 18 months and the redirects and all of those things. So actually, the first starting point for me genuinely is not the commercial considerations, because that would suggest that the people I work with are kind of motivated in that way. And I think the people I work with, for a start, a lot of them who work in those contracts might have been civil servants or worked in my world before, particularly in private prisons. I think they genuinely and generally are motivated to do a good job in terms of what they are in charge of. The operating environment is the first thing we need to get stable for anyone to operate these things well. And you're absolutely, when it is unstable, it definitely has knocked on. And equally, if a court starts late and sit late, then means they arrive late with me. That has a knock-on effect late to reception. So all these things are very systematic.
Thank you.
Can we move on to staffing?
Can I just come in on that point?
Yes.
What would it take to stabilise the operating environment?
We need to operate at a lower level than 99% occupancy on the prison side. In probation, we might be about to start on it in terms of what we need to do to reduce workloads. I'm sure Nick and others will have views about other agencies and how they need to stabilise.
You see, the criminal justice system is a system, just before it comes in, that has been operating at full capacity under incredible strain, as Amy says, 99% full in an institution where you're getting people in and out of all of those estate every day, and the Crown Court backlogs going up. So I think what it would take is a period of stability, and then a sustainable system that isn't full to the max. Yeah.
What is a sustainable level? Like, what's actually a sustainable, viable level, and how much money does it take to get it there?
Well, I don't actually at this point. I don't know if money. I mean, first of all, there isn't any money, but as it were, or not, perhaps not significant number enough. But it's not. I think money isn't the only answer. The government's position is we've got to get to a more sustainable size of system, and that is what the Criminal Courts Review and the Sentencing Review will deliver, or will identify options that ministers will make decisions on the policy about.
Just to amplify some of that, the reality is that the capacity of the justice system is relatively fixed. I mean, they've been trying incredibly hard to increase that in prison probation, but demand is exceeding supply in just about every jurisdiction we have in the courts at the moment. So across tribunals, certainly in crime as well. And if you think about the lead-in time of building courtrooms, getting judges, it is years, if not decades, and you need a healthy legal profession to be able to grow that. So we have a very, very fixed supply base, and it cannot flex really quickly. And when you run it at such heat for such a long period of time, it creaks.
To try and give you a straight answer from my perspective, I don't think we should run the system any hotter than 95% occupancy.
Okay, thank you. Lizzie.
Thank you very much. You've probably gathered that I'm interested in the people side of things, having worked in the courts for many of the 21 years that I was in the CPS for. So if we can turn to staffing, that would be something I'm interested in. But let's stick with, at the moment, the cost side of things. I know we've concentrated on cost and efficiency savings have been mentioned already this afternoon. So the annual report for 23-24 identified 893 exit packages, which cost £46.6 million, which is interesting because I know that we're not inundated in this country with staffing in the Ministry of Justice. Can you just outline the exit packages briefly and the types of exit packages, and also when you would choose to use them within the service?
Well, I'll say something about the types first, and then the lion's share of all those exits are in HMPPS, so Amy will want to add. So essentially there's 2 or 3 types of exit. There's medical efficiency exit, which is where, for various reasons, somebody can no longer continue in their job for medical reasons. That's a particular type of exit. There are, and in fact, that in this case, 576 of the 893 were medical efficiency exits. And then there are exits when that we call would either be voluntary exit or could include compulsory redundancy type exit, which is where somebody's job, for various reasons, their job no longer exists in the way that they were doing it, and there's no other appropriate role to be found. And in the year in question, there are 272 of those sort of exits in HMPPS and 1 in HMCTS. So, Amy, do you want to say something about HMPPS?
Yeah, of course. So on those 2 types, on the first, you can appreciate, given the operational nature of our work, that it's fairly routine that some people are just not able to continue in employment with us because it's medical inefficiency. We have requirements for certain levels of fitness to undertake control and restraint, CNR, etc. But I guess the more interesting, because it was unique in the last year, is the beds package we had for 1 HMPPS. So just to very quickly say what 1 HMPPS was designed to do: 2 things. Make sure that in 7 regions we had an area executive director, which means that we have someone that oversees both prisons and probation to try and drive the join up between the system, and in particular the fault line of going into custody or coming out of custody. But also to make a reduction. We set ourselves a target of 37 million to save from headquarters so that we could invest in the front line. We achieved that through a combination of 20% reduction in headquarters, but also some reduction of change programmes, and those voluntary exits facilitated that. We think we'll save 18.6 million a year, so it will kind of pay back and wash its face by the end of this calendar year, really, so just over a year. And then the reduction in headcount is permanent in headquarters.
So, as you'd expect in efficiency, so when you're seeking to make efficiency savings and you're doing it through a restructure, well, I mean, the restructure might be delivering lots of other things, including better outcomes and better ways of working, but alongside it, if you need people to exit, then it's normal to have a voluntary exit scheme.
Were the efficiency savings just because of that restructure, or were there efficiency savings elsewhere as well?
So what's slightly confusingly, what's described in the report as efficiency exits are actually the medical efficiency exits. Okay. So the number to which the is it 24 million pounds relates is the 576 medical efficiency exits. The other exits, the voluntary exits, were the 272, so the smaller number. And we do have a small. Well, as I say, there were 2 in from HMCTS, and I don't know if we had a handful elsewhere. James, no.
Thank you. That's really helpful. Are you expecting to have to make any more efficiency savings for the next year, for 24-25 and beyond, at the moment, that aren't medical, that are simply efficiency savings?
So I'm definitely expecting, in line with what the Treasury are asking for every government department to do, to have to make some efficiency savings. Of course, what we're talking about is exits that come from staff departures, but that, like, as it were, to be determined. But because, you know, when you are seeking to make efficiency savings, there's many ways of doing that, and obviously you can get more efficient by being able to do more with the same, or you can seek to reduce the number of staff.
I think it's worth just...
Oh, yeah, and actually we've got a particular issue.
It's probably just worth touching on the courts there. So we are reducing our spend, and most of our spend, a lot of our spend is in people, so we are reducing the amount of staff we have in HMCTS, and we've been doing that for a couple of years, and we'll be doing that for 2 or 3 years hence. They don't show up in these particular figures, so they're not, they don't attract a voluntary redundancy scheme, or they're not retired in this way. We are making those staff efficiencies by investing in our digital services, but they just come out mainly through natural attrition as staff retire, as they leave and so forth. So there's quite a big chunk of workforce leaving there, but it doesn't show up in these sort of payoff figures, if you like.
Because you, in HMCTS, you have the highest turnover of staff, I think 14.5%, 23 to 24, against the civil service rate of 7.5%. So does that concern you? Do you think that's a problem?
So at that point in time, that was true. Yeah. And in part that was to be expected, because as I've just set out, because we had investment to digitalise the system, we then have to recoup that investment by cutting our costs. And therefore, for quite a long period of time, we held quite a lot of staff on fixed-term contracts in anticipation we would not need them in the future. And that high percentage figure includes staff whose contracts came to an end, and other staff who basically we were scheduled to have to lose at some point in time. I don't like losing staff. We've got some really good, loyal staff. That figure's come down a lot since, so it's now at around about the 10% figure, which is a good thing. But we do lose quite a lot of staff. As I say, because we have to cut our headcounts, it's more or less in balance. There are some staff, some specialists that we're particularly keen to make sure that we have a good supply of, but it's natural to lose a certain amount of staff. They generally lose. Quite a lot of our staff leave because they're retiring, so we've got an ageing demographic. A lot of our staff are 55 to 60. Unfortunately, they're coming to the end of their career, and then 2/3 will leave for further reasons, either promotion or resign to work outside of the public sector. So we do get that turnover. Yeah.
There are quite a lot of internal transfers within the civil service, isn't there? And I think particularly in HMCTS, do you know why people are moving departments? What's driving that?
Yeah, we know why people leave. So there's quite a lot of focus when we talk about the courts about our legal advisors are critical to keep the magistrates' court running, leaving to the CPS. That's often something thrown at us. Actually, the figures there aren't as dramatic as you would think. And on that, we've been really successful. We've recruited more than we should have. We've got a lot of bright young legal advisors now coming into the magistrates' court, so they're making a big difference. But we do get a lot of people leaving, particularly for the other big operational departments, the Department of Work and Pensions, HMRC. They generally leave promotion or pay increases. Our staff, 55% of my staff are paid £23,000 or £24,000 a year, and there are better paid alternatives out there. They're incredibly loyal, largely, but of course some will want money elsewhere. Yeah.
Is there an issue with career progression opportunity? Is there an issue within HMCTS on career progression opportunities for staff?
So it's quite a complicated question. No, I mean we've got good developmental schemes. We want to get people through the grades. We definitely do, and sometimes actually we find it difficult to get people to take a different job. They may perceive it as more stressful, and certainly we see that in some areas. But generally speaking, we've invested a lot in trying to develop people through the grades. We've got some really great schemes, but it's not for everyone to move through the grades. But yeah, the offer is there. We've got a really good offer, and we're particularly trying to make sure that that's better for particularly lawyers, young lawyers coming in. There is in some areas it's a bit more difficult to advance. If you're a lawyer, there's sort of a ceiling within HMCTS. We don't have very many very senior lawyers, but there's potentially a judicial career, and we're trying to highlight those benefits, and with some success.
Could I just add on that? First of all, moving within MOJ, I think is a good thing. So, I mean, obviously you want people to stay for some period in their job, but we like it when people who have policy experience go into operations, or who have operational experience go into policy, and that's one of the things that we can offer as a department, because we're a department that runs the whole spectrum. So we think it makes us better at what we do if we have people who have worked in lots of different bits of the system, because one of the issues about the CJS is it's, as you will know, it's so complicated, well, indeed the whole justice system, and it really needs to join up more. So moving within MOJ is a good thing. And I have to say, also, people leaving the civil service, I think, is a shame. But people who leave MOJ for another department, if they're going to get more skills, I mean, a number of us have worked in other departments. That's one of the things that the civil service also can offer, which is knowledge of different areas. So it's not necessarily a bad thing if people leave the department for somewhere else in the civil service, especially if, and they often do, come back because MOJ is such a brilliant department.
I don't doubt it. And I agree, for the people, for the staff involved, that's an incredible opportunity that they can move between the departments. What I'm concerned about is what we've been seeing in the courts, that I think Nick's just mentioned the word stressful, and I'm concerned about people leaving because of the impact of the current criminal justice system, and the impact that has on the staff. So probably a question for you, Nick, and I think I know the answer, but the current pressures that courts are under with the court backlogs that we see at the moment, is that also a driver in staff moving to other departments or leaving altogether? And if so, is that something that you're concerned about?
Quite a complicated question. So firstly, we ask staff every year how they feel, and that includes a sort of headline engagement score, and broadly speaking, actually, a headline engagement score. Actually, we got a bit of a boost in COVID. People felt really valuable in their work, but it's about as high as it's been, and it's stayed steady despite the pressures. So that doesn't tell us that we're in crisis. We have something also called a perma stress index, which indicates how stressed people feel, how positive they feel, and again, that's not in a sense of decline. It is true people feel pressure, but they also feel pressure in two ways. Actually, when you go to a court and they're sitting at full tilt, sometimes there's a great sense of achievement to come with that, and genuinely staff tell me that. Sometimes it's just too much as well. So it's quite nuanced and quite balanced, but how we measure it indicates that, broadly speaking, staff are feeling valued. They are under pressure, I think they are, but they do feel valued, and they should, because they are.
They're doing an absolutely exceptional job as well.
Under pressure.
But under pressure, which is why it's particularly exceptional.
Supplementary. Yes. On this question of workload and that kind of thing, would do you think court digitisation, court transformation programme, IT programmes would assist in alleviating the pressures on staff, and where are you at with that? Maybe you were about to ask that. Yeah.
In the courts context, it's quite complicated in terms of how it works, because what effectively it does is it removes quite a lot of the administration work that is typically done in the back room of a court. And so that work is being removed. But what that's meaning is that quite a lot of that work is going to our service centres. So we've got 5 national service centres now who pick up the phones that used to go to the phone calls that used to go to magistrates' courts or Crown courts. They deal with the admin, they get all the documents ready, and so forth. Now, so that's a good thing. That is reducing pressure on the person in the court. What they will feel, though, and what judges feel a bit, is actually there's just a fewer people around the place, and it's quite difficult to explain, well, there's 3,500 people sitting in call centre helping you. So, broadly speaking, it does reduce admin pressures. They can't see who's now busy with that, so it is quite a complicated thing to explain.
Yeah. I think the other thing... Oh, sorry. I was just going to say the thing to add, which Nick knows better than anyone, is I think sometimes the end state alleviates the pressure, but the process of delivering the change and the reform while also continuing to do the day job actually can increase the pressure in the short term. So we're a department with a huge number of change programs ongoing while we're delivering absolutely crucial public services, and in those periods you can see stress increase because people are having to learn something new alongside continuing to deliver. It's the famous build of the jet plane while fly the jet plane.
It might be worth me just amplifying that. That's certainly true. We've been asking staff to work incredibly hard coming out of COVID. At the same time, we put a lot of change upon them. So they've had a bit of a double whammy. We're coming to the end of that now, and actually that's quite a good thing. And I think we're beginning to see that we can come out of it, but they have had to deal with that. Also, when you fundamentally change systems, staff are dealing with the old computer system, the residual stress of paper and a new system. And what we really need to be doing over the next few years, and we started to do, is simplify back down. This is the way we're going to be running things now, but they have had a lot to juggle with. So
I think this committee's heard that there's been a £1 billion attempt at court transformation which has failed. And again, taking us back to public value for public money, and who were the contractual agencies responsible for that £1 billion failure is of interest to us.
It's far from failed. It's delivered a lot. This was the biggest transformation project in the justice system ever attempted globally, and that was how ambitious it was when we set out. We're coming to the end of it now, but it's delivered a huge amount. We couldn't have got through the pandemic without having digitalised.
Shall we deal with that issue as you raise it, Pam? We'll go back to prisons in a minute, if we may. You wrote to me on the 13th of February, Mr. Goodwin, with a sort of summary of what you thought the court reform programme had achieved and where it hadn't, and where things have been taken out of scope in that way. So yes, clearly there are issues. I suspect, I'll let Pam correct me if I'm wrong about that, what she meant by failure is we've spent the money, the £1.3 billion. Certain areas have gone according to plan. Some have gone ahead in a modified way. Some you've got new digital systems running aside old systems. Some are out of scope entirely. Overall, though, it does seem disappointing, and put it no stronger than that we've got a situation where what was ambitious was extended over a number of years, has now gone on for, 9 years? And which, what I couldn't see from what you sent me, and I know we've written back, we've asked for when a full evaluation is going to be published, so you might want to deal with that point as well. But none of the targets have been reached, targets in terms of reduction of staff, in terms of savings going forward. So yes, obviously, and you'd expect for the amount of money spent, some things have been achieved, but overall the programme has not been a success, has it?
To address the general point, it was incredibly ambitious, but it has delivered a lot. It was in crime, civil, family and tribunals, and substantially, many of those jurisdictions have been completely changed, or will be completely changed very, very shortly. And yes, we would like to go on further. When you're doing a project of that size, with a pandemic in the middle of it, there's going to be some changes along the way. And there was quite a lot of decisions that we had to make along the way. But essentially, as well as us, and I can talk a little bit more about the benefits we're accruing from that, we've also managed to really improve services to the public here. So if you look at the satisfaction rate, so no one likes getting divorced, no one likes getting a speeding ticket. But if you ask people who've gone through digitalised service, how was getting a speeding ticket through justice procedure, 83% of them say it was good. You ask them how was online divorce, and over 90% say that was good. Our savings are made up of reducing administrative time, largely in the courts, or allowing the judges to be more efficient. Now, I'll quickly run through some of that. But for every saving that we make, generally speaking, that is something that comes to the court, that it comes to the court more slickly now. Every court case has at least one, possibly two, possibly three, multiple parties, all of whom also get that benefit. So when you think about the transactions with DWP, with the Home Office, with local authorities and public law cases. There's a kind of a much wider dividend there than I spelt out in my letter when I was talking about where we are on the benefits. Where we are in terms of achieving the savings at the moment, and this will continue, I think, to improve, is that a year or so hence, when we get to completing the reforms, we'll be saving £135 million from our budget every year going forward in the courts, and that's a big chunk. That is less than we set out to. But if I can just explain where the reductions come from. So there's three buckets where we lost some savings. The first is what we call judicial benefits. Now, that's a bit of a misnomer. What that actually means is there were certain reforms that we thought meant that we can make the judicial day more effective, and we've got many of those, but there are some that have not come through, and all of those relate to whether we were successful with digitalisation at all. In fact, largely they don't. So within the business case, it assumed that the panel composition in certain tribunals, for example, the Mental Health Tribunal, would change. It assumed that judges in immigration, rather than spending one day hearing a case and one day writing it up, would spend 2 days hearing cases and 1 day writing it up. And it also assumed that judges would become 10% more efficient generally without anything, particularly underneath that. And they've proved really, really difficult to realise, partly because they don't relate to what we do in reform, but partly because the complexity and weight of cases in the system meant that actually saying that they're achievable wasn't there. So that's a good third of where things have reduced. We haven't achieved all the staff savings. So there's about 1,000 staff that we've retained that we thought, when we were setting assumptions back in 2016 and then 2020, you might be able to get rid of. What we've provided here is actually an assessment of where we are in the real world, right? Not the assumptions that you made back in 2016. And we found it really difficult to get rid of 1,000 staff that we thought we would. And that's for two reasons. So one reason is, when I look at the Magistrates' Court and the Crown Court and the amount of work that they have to deal with, saying I'm going to take 300 people out of the Magistrates' Court and 300 ushers or court clerks of the Crown Court was a real risk to service continuity as we were trying to deal with the backlogs. So in those circumstances, I think you've got to say, the health of the courts is more important than delivering on a particular line in a business case, and they're the sorts of decisions we had to take. Then there were some reductions in scope. Now, we lost around 15% of our benefits through scope reductions. So if you take that proxy of how much we delivered, we probably delivered about 85% of what we set out to, which is pretty good. And there were some areas we had to take out of scope. There were really difficult decisions. Every time we took that decision, effectively we were prioritising what was going to give us the biggest bang for our buck. And we decided not to digitalise some of the smaller tribunals, and some stages of civil we also decided to deprioritise. So there were some lost benefits there. And then there were some other areas where things didn't turn out quite as we'd liked. So when we first developed Common Platform, which is a system in the Magistrates and Crown Court, the original aspiration was the Crown Prosecution Service would be fully integrated into that system. That's not how it works now. We've got a really good interface with the Crown Prosecution Service, but that original notion fell away over 3.5, 4 years ago, so that's no longer there. And then, of course, there's a few bits along the way. So if you kind of add up what I would like to be a better savings figure, the actual kind of scope piece is a very, very small part of it, and the rest were actually very, very, I think, sensible and level-headed business decisions.
Well, I continue, just Lindsay, you want to go in?
Yeah, just off the back of what you were saying about the 1,000 staff that you've retained, and may I say rightly so in my opinion, just stepping away from the courts and looking at the MOJ, in the wider MOJ, Ministry headquarters have had increased staffing by 66%, with an increase of just slightly under 3,000 full-time equivalent staff in 23-24. Whilst we know there are challenges on the front line, so could you maybe, Antonia, I think it would perhaps be best answered by yourself, just explain what the benefits of having those additional staff in Ministry headquarters would have, both on the frontline staff working in the MOJ overall, and also on the public through the MOJ.
So in the number that you mentioned over the growth over the last 4 or so years, so 700 of that number came following probation unification. So when we insourced what had been outsourced as part of probation, obviously that included a number of essentially HQ tasks, accountants and all the people who would have been doing the work, kind of running the thing, who weren't on the front line. They came to HQ, not to HMPPS. About 1,300 of that number is the digital and tech capability that we've built up. We've got a Justice AI Centre now doing a lot of, back to where we're going to find these efficiencies, all that work on digitisation, automating, etc. We've done some further consolidation of functions. So the functional leadership model essentially says try and do it once. So rather than have every agency or ALB have their own function doing, say, HR or commercial, we centralise them, and that's been a journey. So over time, I think it's been about 200 of that number were moves into James's corporate centre from, I think it was HMPPS in that case. So essentially, it's been a combination of consolidation of the functions, a specific insourcing programme, and then deliberately building up, which has been part of our workforce strategy, our digital and tech capability.
On the digital that we know has caused problems
slightly
in
different,
terms
I think,
of the finances.
Although slightly different things. So what Nick was just describing, which is the reform programme, with which I agree with what he was saying, some of that is still run because HMCTS is essentially a joint venture between the Lord Chancellor and the Lady Chief Justice. That has still, a lot of that work sits within HMCTS. What I'm talking about is an investment into Justice Digital, which would include that and work closely with the team in HMCTS, but actually is going to go much broader and look at how we can deploy technological innovation in, say, for example, probation, or for, we were briefly discussing tagging earlier. So there's a huge amount of work that we think we need to do on the justice and tech side. So I don't think that's an area that has been...
Where I see we are now, and I tell you if I'm being unfair here, is the reform programme and common platform were ways of taking mainly paper-based systems and digitising them that way. Now, about half of the judicial workload in the county court will now be progressed digitally rather than being issued on the old legacy systems, requiring paper handling as cases progress. So yes, there's been a substantial amount of work done, but there's a substantial amount left to do. So you're talking about other areas where technology, but what is happening we haven't got as far, or you haven't got as far as you intended with the reform programme. What are you going to do now? If there's no money about, are you going to continue in a hybrid fashion? You've de-scoped quite a few parts of the programme. Enforcement, for example, which is important. You might have a digital system until you get to enforcement, and then you're back on the paper-based system again. So what's the plan now?
So I'll come back to the county court. Family, we'll be rolling out private family law. We've got public family law in. So family digitalised very shortly. We've done the job in the Crown Court that we set out to do, and we've digitalised all the main tribunals. Okay, so there are some smaller tribunals that haven't been digitalised. In the county court, there is a bit more work to do. So some of the reasons things came out of scope was because there was big policy changes happening, and that's certainly the case in respect of housing possession. So as that legislation comes into being, we will digitalise our housing and possession cases, and they will then become digital cases. Enforcement was also taken out of scope for, broadly speaking, 2 reasons. The first is it's right at the end of the process. And what we wanted to make sure was as much as the process was fully digitalised on end to end before we went into the process of doing enforcement, because it would have just floated off on the end somewhere. So we had to prioritise getting as much as the end-to-end to that point done. We also, there were, at the time we were doing this, other policy changes coming in the civil courts that meant it made sense, because we had too much uncertainty, to digitalise enforcement at that point in time. Now, there are other parts of the civil reform journey we didn't get to, and the big one that people always mention will be bulk claims. And the reason why, we had to make some really hard scope decisions at the end of the reform programme. Now, that was because, frankly, we were running out of time and money, and we wanted to prioritise the things that gave us best bang for the buck. In respect of a bulk claim simply means high volume claims. They can currently, and will continue to be able to do this, they are issued digitally. Now, the thing with a bulk claim is that a very, very small percentage of those claims are ever contested, ever come before a judge, and therefore ever have to go onto the paper. But because they are so high in volume, that does happen, and that is the reason why, when it comes to the judge's work, by the time bulk claims come through, there's still too much paper in the system. We very much would like to get the job done there. I've kind of got a burn down of how we can get rid of paper in the court. So in the county court, and we are talking about the county court civil jurisdiction over the next period, we're making the case for that. But we do begin to eat into it very quickly. So by the time we're through housing and possession, and by the time we've done everything we've got scheduled, 91% of all cases will be issued without any paper. And we will get to around 61% of cases being truly paper-free by the time it reaches the judge. The rest is not that difficult and remote to do, and we definitely want to do it, and we'll be making the case for that, because it's a kind of a no-brainer. But we had to be really pragmatic. We had to get as much out of the court, get our bang for our buck, and they're the difficult calls we had to make.
But we went to central London before Christmas. We're intending to go to Northampton, to the National Business Centre, in a couple of weeks. A lot of paper. If we go back in 10 years' time, will it still be the same?
So those two areas are the two areas there are most paper, right? So, I mean, I don't know if it's coincidence you went to the two paper-heavy places or not, or whether you maybe directed there, but the Central London County...
And you're a
I wonder.
Conspiracy.
The Central London County Court is the really difficult end of the civil reform journey, because what they deal with is the most complicated cases that are most likely to be bumped up into the High Court. So that is the really hard end of complexity, and what we're discussing, what we're trying to do in preparation for making the case for further investment is, how we do that. But that is the really hard end of it. Northampton is a different thing. Northampton relates to the fact that there are still some paper cases in the system, and we need Northampton to deal with that. That is changing pretty radically. To be honest, in this journey, there's always bumps along the road. We didn't get it completely right in Northampton over the last couple of years, but their performance is now really, really good. So any of the concerns you may have heard about their performance slowing down the county court is dissipating incredibly quickly, and the ambition is still very much to eventually do away with the need for the paper to be handled there. Yeah.
Go on. Go ahead. Well, my last question, what is preventing you from going ahead with the parts of the programme that haven't been achieved? Is it simply lack of money, or do you think, or have you revised your view that it's no longer, the cost benefit is not there? I'm assuming you're going to do a proper evaluation. It's such a large programme, and publish that soon. But it does feel to be hanging in the air to some extent now. So where do we go from here?
Well, we'll certainly be doing that. So you wrote me a letter. I'll be responding to your letter, setting out really as clearly as possible exactly where we've got to everything. All the way through this programme, we've been conducting lessons learned, we've been reviewing things, and we've had 3 NAO reports into it, we've had a number of independent reports and how we're going, and every single programme has been learning lessons along. We've got a great big library of learning that we take really seriously, share with others, and it's been quite profound learning, to be honest. So all that, rest assured, is there. The Ministry of Justice will be conducting a sort of big MOJ review at the end. That's focused very much on things like, have we improved access to justice and so forth. The other thing that we have been publishing, and they're really, really interesting reports, because we've now digitalised, we've got a lot more data on what's going on. And we've also got data on the basics like demographics and protected characteristics. And what we're doing as we go along is seeing whether a person with this characteristic is having more difficulty interacting with that sort of service, and that is allowing us then to improve those sorts of services. And they're available for you to see as well. So we will be bringing it all together to share, but as we go along, we're publishing more and more information of that as it comes together. So we're trying to be as transparent as possible.
Okay, Ben.
I just wanted to, while we were talking about paper and mountains of paper, we saw that in the county courts we've been to, and other lawyer colleagues of mine still have the bundles are huge, and every prison we've visited has been paper based, and that has a huge effect. It's a huge inefficiency in the system, has a knock-on effect for prisoners where the information doesn't pass through the system in the way that they need it to. So I don't know if there's any brief comment to be made there on the digitisation of prison flow of information.
Well, would you want to go first? Yeah, I'll go first. So, I mean, look, perhaps say something about overall what we're trying to do with in terms of our data. I mean, I was referring earlier to the fact we've built up this capability. So we've got three things we're trying to do with our transformation programme. Thing one is firm up the core foundations, so actually improve the legacy systems that are in place. Secondly is redesigning existing services, so where possible, automating, where possible and where we have the money to do so, digitising. And thirdly, we're looking to ensure we're designing all new services with tech at their core. So actually thinking kind of user first from a tech perspective and the way that people will want to interact with the government in a technological way rather than in a paper-based way. So we've got a plan for doing that, and some of our aforementioned ongoing work on the SR and discussions with the Treasury will be about seeking to think about how we can invest in some of that. On prisons, I mean, there's prisons and probation, because probation is a very manual, not very manual activity. It involves deep expertise, but also there are some manual elements that can be automated that Amy will say something about.
Just a quick point before Amy comes in. Two things worth noting in respect of the prisons and how they operate with the courts at the moment and through reform. The first is, through Common Platform, we are able to send results the moment they are resulted in court on the day to Amy's team for them to do what they need to do in prison probation. That is a much better, slicker, safer, more secure process than the passing of paper for. The other thing we've done through our reform programme and with Amy's team is, last year there was 64,000 video contacts between prison probation and courts. And so the world has changed quite a lot because we have been focusing on digitalisation. Sorry, Amy.
Well, just to say on the kind of narrow particular point in the link with courts, I think Nick's covered it and you're absolutely right. It's a huge benefit for us to get the outcomes so quickly, to be able to know exactly. As you know, also people often think that, a prisoner goes to court and gets one sentence for one offence. It's very rarely like that. It's multiple offences, interacting, etc. So that kind of digital system has made a huge difference. More broadly, I don't know if you want to get into it, but there's digital services that we're trying to approve in prisons and both probation. I don't know if you want to get into that now or...
We'll save that for another day, but it's good to hear.
We hope we finish at 4:30. Got a couple of areas still to cover. We said a bit about prison building. Did you want to say anything more about that, Tesla?
Do you want to do? Sorry, prison building.
I wanted to ask a couple of things. I wanted to ask a little bit about prison building and the increase in places that are going to be needed from 95,000 to 105,000, and that's over the next 4 years, isn't it? As anticipated. So the extra 14,000 additional places that were going to be in the 3G prisons, weren't it? Grendon, Garth and Gartrey, they're going to happen after that date, and I just wondered how are you going to meet that increase of 14,000 places?
So the 14,000 is made up of a number of things. There's 4 new prison builds, although one we're about to open, Millsyke, and then the 3 that you referred to, for which now 2 have planning permission and one is still in the appeal process, having been 40 months in the planning process. But then there's also a number of areas like building additional house blocks, there's rapid deployment cells, there's other ways of bringing supply online beyond those new prison builds. So we're hoping to open some house blocks in additional house blocks in the next few weeks. But I mean, do you want more detail? Yes.
You'll be there, will you? You'll get to your 14,000.
Yeah, so the 14,000 is made up, as the Permanent Secretary says, of both of building on completely new greenfield sites, but then also a lot of expansion on existing sites. And we do that through a variety of ways: house blocks, small secure house blocks, rapid deployment cells, expansion of the open estate. So the 14,000 is a programme of a mix of those two things.
If I could, I wonder if your question, apologies, is also getting at the underlying growth in demand and how we're going to meet that. So there's two things going on. Roughly speaking, every year there's about 3,000, if you like, equivalent prison places worth of demand coming to the system. What we've now done, and I hope it's helpful both for the committee and for others, is we've been transparent on the profile of supply, which is the 14,000 places. We also publish our projections of demand over the course of roughly the same period. You can look at the two and you can look at what the gap is, and in effect what the Lord Chancellor has set out is that the combination of the sentencing review and the supply need to combine to meet those overall demands. So I think the plan is always a combination of both. It's both the supply and the demand measures we want to take.
Okay, thank you. So can I just move now to the number of cells effectively that are out of action, and how that's being dealt with. And I know in particular we've got Dartmoor, which has been shut, hasn't it? It's going to be shut for another 2 years. But have you got a date when it is due to be back on? Because it's got 3 years from last August, hasn't it? So that takes us to August 27. Is that correct?
Shall I pick up a couple of bits? So on the first part of your question, on average last year we had about 1,700 places out of use at any one time.
We've already heard they're being turned around in 24 to 48 hours.
Some of those, so that's two different things. So some of those places that are offline are just because a prisoner might have gone in there and damaged the cell. They're turned around very, very quickly. These 1,700 are places off for major work. So that would quite often be FSI places. So, the fire improvement works, or big, what we call priority one, so replace a whole boiler, do all the showers, redo the flooring, etc., etc. So that 1,700 is kind of major maintenance work.
And that's fairly consistent across the estate, across time, isn't it?
Yeah, that's
so
an
that's
average
a
of
rolling.
Yeah, exactly. That's an average of what we've used. I actually had a red line, which I think we've talked about in the committee before, about continuing the 1,500 fire FSI works, and that's because we have committed that any of the 23,000 cells that are not remediated, that don't have the necessary inbuilt smoke detection, will be taken offline at the end of 2027. So we've got to keep a good profile of work, otherwise we're going to lose too many cells at the end of 2027.
And thank you. And I wondered, so we've already been talking, haven't we, about ISG and how they've come out of the process, really, and what have you. So I presume that the Cabinet Office is now tendering new services to...
Yes, exactly.
That will allow you to carry on with this programme rolling through into the future. And
exactly right. We have got a number, so we never just used ISG, we used a number of contractors. We are optimistic that the slack, if you like, created by ISG, the gaps will be picked up by others. But I think it is, fair and honest to say there's probably going to be more cells that are not remediated by the end of 2027 because of the ISG issues than we had hoped for. We will do our very best to get that work picked up. But the other problem is now, in order to have that work picked up by someone else, I'd have to have even more than 1,700 places offline, which, given capacity, is a very difficult thing for us to manage at the moment. Did you want me to pick up Dartmoor?
Please.
Yeah, so just on Dartmoor, we don't know. The straightforward answer is we don't have a date when we were put back into use. That's because we need to get to the bottom of where we are with the HSE on regulations that govern other persons, which is the way prisoners are classified in the prison, which is a bit different from residents, which I think we ended up talking about a bit in PAC. And then I will be able to decide what remediation works I can do and how effective that is. And until I've gone into contract for that, because I know what the regulations will happen, then I can't know what the end date is.
That presents a problem, doesn't it? Because, I mean, I know, so I had HMP Shepton Mallet until 2013, and that was, 400 years old, jolly cold, very effective, in my view. Very few escapes, mainly because the walls are 40 feet high. But I, having been to Dartmoor as well, there are challenges, aren't there, with that particular building, but I presume there's an enormous cost if you just leave that empty into the future, because it's just...
Yeah, I mean, so first of all, I remember Shepton Mallet very fondly. I even worked there for a little bit on detached duty. In terms of Dartmoor, it's very clear to say that my position remains, we very much hope to get it back into use. One, it was a good prison, as you've said, although it does have challenges, its location and various things, the buildings, not just radon. But two, there's no way that anything else we could do, so building from scratch, would either be done more quickly or in a more cost-effective way for the taxpayer. So we very much hope to be able to get back into Dartmoor.
Thank you. Thank you very much. I think.
Oh, sorry.
So in terms of some of those things are levers that you control and some of them are not. So in terms of the legislative element, what's the timescale for that? When?
I'm sorry, just could you tell us a bit more which legislation did you have in mind, just so we can focus on the right thing?
Sorry, possibly it wasn't legislation. You were talking about not currently really. It sounded like there was a point about prisoners being treated as other persons for the purposes of legislation. It sounds like there's a lack of regulations. Yeah, is there a lack of legal clarity? What's going on there? Could you unpack that in a way that is unintelligible for a member of the general public? Because how many places are we talking about in this prison?
640.
Okay, so this is a significant element of capacity.
So we'll do our best, and obviously I'm sure you'd appreciate that given this is a matter of sort of safety and radon causes lung cancer, it is vitally important that we understand not just the regs but also the health risks that underpin it. So
you
we're
regret
speaking
now signing the new lease for Dartmoor, because it looks like it has very serious problems.
Did you want us to answer the question on the regs first, or
Say a little bit about, should we say a little bit about what we can do about the...
I'll try and be brief and then we'll bore the committee. Broadly speaking, the way the regs are drafted refer to a category of other persons, and they refer to an exposure limit that those other persons can get. It is ambiguous whether that exposure limit relates to the total or the level, for example, above the background level of radiation. And these are things we've been seeking to clarify with HSE and also with our colleagues who work on health protection. It is important both to be compliant with the law, but also, as I'm sure you'd appreciate, for the safety of the people involved.
Yeah, both the staff and the people.
There are several other issues, but I won't bore the committee with it unless you want us to focus more on this.
Straightforwardly, I don't. No, I don't regret signing that lease. It is certainly true that the issues with radon have become more severe than we were aware of at the time of signing the lease. That's because at the time we signed the lease, we first detected radon at the kind of concerning levels in 2020, but it was not in residential areas, and it was in areas where we thought we could have remediated it. So it's certainly true that the position has changed, because I'm not sure how much the committee know, but it's quite complicated the way you test for radon. You have to leave something there for 3 months, then you have to go away and have that analysed. So none of it is like a quick daily, just go and, it's not like carbon monoxide or whatever, just go and test the level that day. It's quite a long-winded process. But nevertheless, I come back to the facts I've just said. It was a prison that performed well. It's 640 places. We all know the difficulties we've had with planning permissions and other things. If I was to try and start again from zero, it would be a very costly, very difficult thing to do. And so we very much hope with this combination of things that we will be able to get back into Dartmoor.
You've got no plans to build any new prisons. Are there any current prisons apart from Dartmoor that are fully closed or have wings that are fully closed?
No, we've got no fully closed prisons. We did re-roll Cookham, so colleagues remember that was a YCS, a youth establishment. We got 70 extra places and we're building that up now over time. There is a closed wing actually at Dartmoor, and it is separate from the radon issue because it's been closed for a number of years. And we will consider, if there is a value for money case, to reopen that wing when we do the remediation works, because it's clear, excuse me, whatever happens now, there'll be quite significant remediation works, which might give us an opportunity to do what we need to do to bring another wing, and that would be on top of the 640, and that has been out of use for a long time.
And Wandsworth, is that now full?
But no, but we've taken places out of Wandsworth. They would be part of the 1,700 that we talked about earlier, because we're doing 3 sets of work at Wandsworth. And I know there's a lot of interest in the committee in Wandsworth. We're doing the fire safety and shower remediation. That started in 24. It's a 4-year programme, finishes in 28. We're doing PIDS, that's perimeter security detection and CCTV. Sorry, did you...
No, I'm sorry to keep interrupting. It's just I'm very conscious of time, and I'm conscious that we always end up these sessions not dealing with probation.
Yeah.
So we're putting out a probation committee at some stage. So could I just, I'll ask my colleagues so I don't keep hogging the mic. Did anybody wish to ask any questions around probation this afternoon?
A broad one around the prospect of devolution in so many new areas and the implications that may have for the commissioning of probation services. I know in Greater Manchester, for example, they have a co-commissioning arrangement, which is quite unusual. So it would be interesting to hear any thoughts you may have on procurement and commissioning.
Yeah, certainly. So I think, colleagues may know, but I was the equivalent of the Area Executive Director for Wales, so had prisons and probation in my command, both of them when it didn't exist elsewhere. I think in both Wales and Greater Manchester, the much closer devolution ties we have to things to do like co-commissioning as really benefits people on the ground and real delivery. So I'll give you an example from Wales, a thing called Dyfodol, which is a drug services, but end-to-end. So the CPS, right through to the police station, right through the court and right through to me in prisons or probation, have the same access to what drugs someone's been on, what they've been taking. Now, the benefits for the system for that are huge, but also there's huge benefits for the offender. A, the obvious continuity of care, but B, not repeating themselves all the time every time they go through it. That is because of the relationship we have that's different. Greater Manchester, we've taken a different approach to what we do with community accommodation, the same in Wales, which the committee are aware, but it's been one of the game changers for us in terms of providing that 84 nights of accommodation at the end. So I think I've been very clear in this committee, and I will be again, I am not in favour of changing the model of probation for lots of reasons I can go into. I am very in favour of the closest commissioning that we can with bodies. Greater Manchester and Wales, brilliant examples. They're not fully devolved. We have a very close relationship. The only other one thing I would say, though, is you do need the geography to be able to dock into. So both Wales and Greater Manchester have a very defined thing. London, you can argue with Mopac, also has the same thing. We do some very interesting things with Mopac. If you were to take the southwest, for example, much more difficult to find a kind of very clear geography we can dock into. And so I'm very much in favour of that way of working, but we do need a kind of platform that we can dock into that would allow us to do these things, to work with people on a commissioning level, but I'm very much in favour of it.
Does that mean then, mate, there's some light on the horizon in terms of the new approach to commissioning and contractual arrangements?
Definitely. In terms of the CRS, yes, definitely. Yes. And we've learned a lot. That was an example of a first generation contract. We've learned a lot in the first generation. One of the things we're also going to try to do, is not, we commissioned every service separately, so finance, benefit and debt separate from accommodation, etc. This time we're going to put all that into lots, so regions can decide how much of one thing versus another thing that they want, rather than having stuck in lots.
Orinda, did I see your hand?
Yeah. Would you agree that when it comes to rehabilitation, having an effective probation service is absolutely crucial?
Hands down, yep.
So does it concern you that the probation delivery units last year were either assessed as being inadequate or requiring improvement? And also, what's being done to put that right, and what are the causes of having an assessment whereby the probation service is assessed as requiring improvement or being inadequate?
Yeah. So look, first of all, yes, it does concern us, and we're working really hard to try and fix it. So there's a few things. I'll just start with the causes, and then I might do what we're trying to fix it. In terms of the causes, some of it is things that have happened over the last 10 years. So you'll all know there's been a lot of structural reform in probation. That's definitely had an impact. At the time, we were also trying to unify. We had to do that against the backdrop of COVID. All those things provide huge challenges. The other is demand. Demand has increased very significantly for probation. So what are we trying to do? One, train and recruit people, because the workload is too high at the moment. We're very clear about that. 2, we need to focus on what it is we want probation to really do, because it's clear at the moment they will not be able to manage the projected increase in demand, even with our very success. We have been very successful on recruitment, but even with that, we won't be able to manage the increase in demand and improve quality. And so we have to decide where it is we want them to focus. We've done that in a couple of ways already. We've done probation reset, which has taken the equivalent operationally of circa 40,000 cases out of the caseloads. It made a very real difference. But also, you will know when the Lord Chancellor made her speech, we've also talked about where we need to focus for lower risk offenders, and that might be on reducing reoffending as opposed to very intensive supervision done by fully qualified probation officers. So we are trying to do all of these things. And then the final thing, which we touched on, but I know we're not going to get into depth today, is what we need to do in digital services, which in probation is really about a productivity measure for staff who have to spend too much time at the moment cutting between systems, cutting and pasting, drawing together information, because as you know, probation, probably more than anyone, is reliant on a huge number of partners, the police, social services, etc., others, and they have to go and look for that information in too many places. So 2 digital programs that are really designed just to mean that a probation officer can spend less time doing stuff they need to do on the computer and more time face-to-face with offenders. So those are the things that we're trying to do.
Just a very quick follow-up question. So, as you say, if the workloads are too high, then that's going to reduce the effectiveness, so you need to get more people working in the service. But I understand you've had some difficulty in retaining staff. So how successful are you in retention and recruitment now?
Yeah, so I genuinely think we've been very successful in recruitment. We've had record number of PQIPs, that's our acronym for recruiting for qualified probation officers as they come into the service. And one of the problems, of course, is during TR they were not, that there was no recruitment. So we've been playing catch up ever since then. We've had record numbers. At the moment, we have a gap of 1,854 qualified probation officers. We have 1,154 in training, and you will know the Lord Chancellor announced that we were going to recruit for another 1,300, which, to your question about retention, will probably be a net increase of about 700. So it is true that not all of those will stay. I don't want to say to you there isn't lessons that we can learn about recruitment or retention. Of course there is, but we have been very successful. And I would expect in a world like ours, which it is difficult and stressful work, we were talking about that in a different context earlier, I would expect that it isn't the job for everyone. And yes, of course, we can do more to try and make sure they understand the demands of the job before they come. An example of that is we now have a non-graduate entry, which a lot of our PSOs, for example, will want to apply for. They have a very good understanding of the work and what it entails, but also what we need to do to support people to be in a very difficult, stressful environment. I would say that our probation staff are absolutely outstanding. I mean, they are the definition of public servants. They have done a brilliant job with all of the context I've just talking about over the last 10 years. Our retention is improving, but there is more to do.
Thank you. Thank you very much. Unless there's any other final points, I'm going to bring proceedings to a close. That's quite a good note to end on. Could we just say, and inevitably a lot of the questions have been negative and pointing out things which we're concerned about, but could we just add to what you've said about the quality of staff, the dedication of staff in probation service, in the prison service, in the court service and elsewhere. And thank you very much, and thank you for attending another committee. I hope you had enough.
Look forward to the next one.
Well, there we are. You can probably use them. Exactly. You've probably got one or two other things to get on with between your committee hearings. So thank you very much indeed for today. Thank you to the members of the committee, and I will end proceedings there. Order.